A very good morning to Dr. Fariza binti Romli. I'm Chai Jung Zhao with metric number 295946, and I would like to deliver a short presentation on my 4 weeks practicum at Kuching Court Complex. The presentation is basically surrounded by my observation in court and what I have learned during the internship here. Without further ado, let's start. Since I have been attached to the staff ordinary court, most of the cases I witnessed were criminal cases. Hence, I would like to discuss on the procedure in criminal cases. First and foremost is a remand applications. The remand process begins when a suspect is detained by the police for up to 24 hours under Section 28 of the Criminal Procedural Code (CPC) to begin the investigation. In other words, if the police cannot complete the investigations the within 24 hours, they must apply to the magistrate court for an extension of the detention under Section 1171 of the CPC. For the offences punishable by imprisonment of up to 14 years, Section 1172A of the CPC allows a remand period of up to 4 days, with a possible extensions of up to 3 days, totaling a maximum of 7 days. For offences punishable by imprisonment of 14 days or more, Section 1172B of the CPC allows a first remand of up to 7 days, with a second remand of an additional 7 days, bringing the total to 14 days, which is 2 weeks. The magistrate must also consider any prior detentions when deciding on the remand application and provide the accused an opportunity to make representations, either personally or through legal counsel, as provided by Section 1174 and 5 of the CPC. Moving on to the next stage is summary trial. Summary trial is basically the first stage of the proceeding where the accused will be brought before the court for mention. The summary trial is governed under Section 173A of the CPC. From the very beginning, the charge against the accused will be read and explained by the court interpreters to them in a language they understand. Next, the court will ask the accused whether they plead guilty or plead not guilty. If the accused plead guilty, the court must ensure under Section 173B of the CPC that they understand the nature and consequences of that plea, and the exhibit must be affirmed by the accused. After this, the court will proceed to the judgment. However, if the accused pleads not guilty, the case will be fixed for PTCM, which is Pretrial Case Management. As per Section 172A of the CPC, when the accused decides to go for trial, a pre-trial conference (PTC) between the accused legal counsel and the public prosecutor must take place. This must be done within 30 days from the date the accused is charged or at a reasonable time before case management starts. Following the PTC, Section 172B of the CPC requires the court to begin case management within 60 days, which is 2 months from the date the accused was charged. The case management is designed to ensure that trial dates and procedural matters are settled efficiently. The court can schedule additional case management sessions before the trial begins. However, if there are delays in starting the case management or the trial, this doesn't invalidate the prosecution or charges and cannot be used as a ground for appeal or review under Section 172B5 of the CPC. However, if the accused is unrepresented, the case management can proceed without the need for a PTC. During the trial, as per Section 173C of the CPC, the prosecution will present all the evidence it believes will support the case. The court will gather and examine the evidence, which includes witness testimony and any other material that can prove the case against the accused. The court can also summon witnesses if necessary. There are generally 3 stages for the witness to attend, starting from the examination in chief (EIC), cross-examination, re-examination, and also read cross-examination upon the approval by the court. At the end of the prosecution case, the court must decide whether a prima facie case has been established. If no prima facie case is filed, the accused is discharged and acquitted. However, if the court determines that a prima facie case exists, the accused must present their defense. The accused has three options for defense. Firstly, is to give sworn testimony from the witness box. Secondly, is to make an unsworn statement from the dock. And thirdly, is remain silent. At the conclusion of the trial, the court will assess all the evidence. If the prosecution has proven the case beyond a reasonable doubt, the court will convict the accused and move to sentencing. If the prosecution failed to meet this burden of proof, the accused will be acquitted. And after the convictions, the court will proceed to sentencing. Before pronouncing the sentence, the court normally will allow the victim and the victim families to give a victim impact statement if requested. This statement provides an opportunity for the victim or family to explain how the crime affected them. After considering the impact statement and other mitigation factors, the court will deliver the appropriate sentence. Following the trial and sentencing, both the accused and the prosecution have the right to appeal the decisions. Either party may file an appeal to a higher court within 14 days of the judgment. The appeal may challenge either convictions or the sentence, or both. In regards to the civil matters, there was a proceeding which attracted me the most during my internship, which is garnishee proceedings. In general, garnishee refers to a third party. The garnishee proceedings applies when a losing party refuses to pay with another party. In the beginning, the judgment creditor will obtain an ex parte order from the court to be served to the judgment debtor's bank. The judgment creditor will pray for the bank to show cause whether the money is sufficient to satisfy the judgment sum. Any bank accounts that garnished by such order would have been suspended, and the judgment debtor would have no access to the garnished money. At this step, the garnished money will be frozen to avoid judgment debtor from removing the money to somewhere else. After the money in the judgment debtor bank had been shown cause, the judgment creditor will pray for the garnishee order to be made absolute. Once the garnish order being absolute, the amount garnished will be directly transferred to the judgment creditor. On the second week of internship, we UUM attached students were invited to attend a mock trial which participated by other attached students. Although we were not initially included in this mock trial, as the task had been assigned earlier, we had taken up the opportunity to play some minor roles such as bailiff and investigations officer IO. The mock problem was related to death under Section 380 of the Penal Code, and it was a summary trial. Since the accused had pleaded guilty in the first place and had no objections to the brief facts and exhibit to be tendered, the only wishes for the defense counsels was to mitigate the punishment as much as they can. However, the accused was eventually granted discharge not amounting to acquittal (DNAA) by the court because there was only a police report to be tendered as exhibit, and the format was totally wrong. Throughout the mock trial, I realized that while professionalism and oral skills are the key to win a case, we cannot ignore those minor parts, as these minor parts will determine whether we can establish a case and bring it to the next stage. In this trial, it was clearly an unfairness for the defense counsel to submit, as the prosecutions can prove prima facie case easily. However, due to the law completeness of the documents, the accused failed to be convicted immediately. I am very grateful for the opportunity given upon to conduct my internship here, as everything is new to me. I would like to express my sincere appreciations to everyone who helps me during my practicum, including my both supervisors, court officers, and also everyone I have met throughout this month. It is a valuable memory for me, and I will never forget about the journey. That's all my presentations, and thank you for attention. Take care.